We're going to have a look at Rock Advertising against MWB Business Exchange Centres Limited 1918 in the Supreme Court. It raises three principles of law. The first is that where a contract contains what is known as a non-verbal variation clause requiring that any change or variation to the contract has to be done in writing and signed by the parties, then if the parties don't follow that procedure and they make a variation without putting it in writing, that agreement cannot be enforced. The other area of interest is consideration. And in order to deal with that, what we'll do in coming videos, we'll look at some of the cases that the Supreme Court looked at in considering this area of consideration. The case of Curry and Misa lays down a definition of consideration, and one particular word used in that definition is benefit. So we'll have a look at the case of Rock Advertising and see how they make it clear that some types of benefit can actually amount to consideration. We'll also look at the rule in Pinnell's case that payment of a lesser sum on the day due in satisfaction for a greater sum cannot be any consideration for the whole. We'll then look at Foulkes and Beers, which approved Pinnell's case. That was in the House of Lords. We also look at Williams and Rothery and Reselect Move. Once we've done that, then we'll return to have a look at Rock Advertising. And the last principle that was covered was the doctrine primis estoppel.